If there is no law establishing the office of the special counsel that he occupies, he then cannot proceed with this prosecution. Why? Because a private citizen cannot criminally prosecute anyone, let alone a former president. Hello?
Immunity isn't just immunity from liability, it's immunity from the whole thing, right? If you're immune from prosecution, you shouldn't have to go through the process to begin with. So I think there is no chance we see any trial before the election, and the case is going to disappear if Donald Trump is reelected.
We've admitted consistently that there are acts alleged in the indictment that would constitute private conduct, but we believe that if the official conduct, the immune acts in the indictment are stripped away, that Jack Smith doesn't have a case, that this case should be dismissed on that basis.
Jack Smith in danger. The Supreme Court now commenting on his illegality. The reason why he should not even be on this case is because he wasn't properly appointed as special counsel. He was never a U.S. attorney, never confirmed by the Senate, and his appropriations, all the millions that he's gobbled up from the American taxpayer to prosecute Trump, are not his funds, should have never gone to him. And so Judge Clarence Thomas, judge on the United States Supreme Court, wrote a concurring opinion in the Trump immunity case, which wasn't a majority, wasn't part of the holding, so what he says here is not law, but he's giving a very good hint out here to Judge Eileen Cannon in the Florida classified documents case, who currently has this decision on her lap. She needs to decide whether Jack Smith has been lawfully appointed or not, or illegally appropriating funds. So this is what Judge Clarence Thomas has now said in his concurring opinion from the Supreme Court of the United States. Judge Clarence Thomas concurring in the opinion and writing in the case of Trump versus United States. This is the Trump immunity case. Judge Thomas writes saying, "All right, America, few things would threaten our constitutional order more than criminally prosecuting a former president for his official acts. But fortunately, the Constitution does not permit us to chart such a dangerous course." As the court forcefully explains here today, the framers deemed an energetic executive essential to the security of liberty, and our system of separated powers accordingly insulates the president for prosecution for his official acts. Now, to conclude otherwise would hamstring the various and vigorous executive that our Constitution envisions, saying while the separation of powers may prevent us from righting every wrong, it does so to ensure that we do not lose liberty. Okay, there are things that may escape some of the rules from time to time, but we don't overcorrect. So Judge Clarence Thomas continues, and he says, I write separately to highlight another way in which this prosecution may violate our constitutional structure, and it pertains to Jack Smith. He says, in this case, the Attorney General, Merrick Garland, purported to appoint a private citizen, Jack, as special counsel to prosecute a former president on behalf of the United States. He wasn't a U.S. attorney. He wasn't appointed by the president, confirmed by the Senate at all. Thomas says, the judge, but I am not sure that any office for the special counsel has been established by law, as the Constitution requires. Okay, the Constitution says you fill offices that are established by law. What is the law? Congress. By requiring that Congress, not the executive branch, you don't want the executive to create its own offices. That violates the separation of powers. Too much power in one entity. By requiring Congress to do it, so Congress can make it and fund it, and then the executive branch can run it, the Constitution imposes an important check against the president. He cannot create offices at his pleasure. That would be insane. If there is no law establishing the office of the special counsel that he occupies, he then cannot proceed with this prosecution. Why? Because a private citizen cannot criminally prosecute anyone, let alone a former president. Hello? No former president has faced criminal prosecution for his acts in office in the more than 200 years since the founding of our country until now. Thanks, guys. Now, and that is despite so numerous a number of past presidents taking actions that many would argue constitutes crimes. No, Trump is the first one because he failed to properly label his spreadsheet rows in his TurboTax. That's it. That's the biggest one. Historic, okay? Never happened before. Trump's a monster. Never seen anything like this before. Bad spreadsheet labels. That's the problem. So they break 234 years of precedent because they're maniacs. Now, if this unprecedented prosecution is to proceed, it must be conducted by someone duly authorized to do so by the American people. The lower court should thus answer these essential questions about Jack Smith's appointment before proceeding. Hey, Judge Eileen Cannon in Florida, you listening? Hopefully. The Constitution sets forth, right? This is Judge Clarence Thomas just saying, hey, FYI, this is how this works. works. The Constitution sets forth how an office may be created and how it may be filled. It's very clear about this. The Appointments Clause provides, it says, the president shall nominate. Did Jack get nominated? No. And with advice and consent of the Senate, shall appoint ambassadors, other public ministers, judges of the Supreme Court, and other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. That's Congress. But the Congress may by law vest the appointment of those other officers as they think proper in the president alone, in the courts of law, or in the heads of the department. Okay, so Congress can create these little placeholders and say, we don't need to fill them, but you can fill them. But it's got to be a box for it. Now, the constitutional process for filling an office is plain from this text, pretty easy. The default manner for appointing officers of the United States is clear. Nominate by the president and confirm by the Senate. Clear as day. Now, but the clause provides a limited exception for the appointment of inferior officers. Okay, Congress may by law, so they write a statute, authorize one of three other actors to appoint inferior officers without the advice of the Senate. So when does that apply? Well, as relevant here, it's when a head of a department like Merrick Garland, the Attorney General, is one such actor that Congress may authorize by law to appoint inferior officers without senatorial confirmation. So you can't appoint an officer if you're the AG under certain circumstances. Now, before the president or a department head can appoint any officer, however, so it's not just a free-for-all, the Constitution requires that the office and the officer who is about to go into that office be established by law. Footnote 1 tells us that although a government official may also be a non-officer employee, I'm going to set aside that category because it's difficult to see how an official exercising, he's saying clearly Jack Smith is an officer. All right, I'm not going to even talk about non-officer employees. Not even going to mention that, says Clarence Thomas, because a non-officer employee would never have the power to enforce criminal law. Only an officer could ever enforce criminal law. That's what Jack Smith is doing. If Jack Smith were a non-officer employee, the constitutional problems with this case would only be more serious. So we're going to forget that. For now, I assume without deciding that the special counsel is an officer. We're just assuming this because he's prosecuting somebody, and that's the power of an officer. Now, the Constitution itself does create some offices. Most obviously, we have the office of the president. We have the office of the vice president. Now, although the Constitution contemplates that there will be other officers of the United States whose appointments are not herein, it clearly requires those offices are established by law. Congress writes a law and puts them in. And established by law refers to an office that Congress creates by statute. Now, the limitation on the president's power to create his own offices grew out of the founders' experience when they lived in the English monarchy. They were tired of this, all right? The king could wield significant power by both creating and filling offices as he saw fit. I need a new office. Created, funded, filled. He was emphatically and truly styled, quote, the fountain of honor. He not only appointed to all offices, but he could create them too. They talked about this in the Federalist Papers. Now, that ability raised concerns about the king's ability to amass too much power. The king could create a multitude of offices, throw a bunch of his supporters in there, and this became the most insidious and powerful weapon of despotism, which is basically what we have happening now. Thomas Paine talked about it. He says the crown derives its whole consequence merely from being a giver of places and pensions. Just get on that government teat, baby, and you just keep getting fed. And that's why democracy is such a problematic thing. If it's a tyranny of the majority, that serves nobody. It's still a tyranny at the expense of the minority, and you have a top-heavy democracy that then bankrupts itself, as we're in. In fact, one of the grievances raised by the American colonists in declaring their independence was that the king had erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. Sounds familiar. Now, the founders thus drafted the Constitution with, quote, evidently a great inferiority in the power of the president, in this particular to that of the British king. Now, the founders broke from the monarchical model by giving the president the power to fill offices with the Senate approval, but not the power to create offices. Judge Clarence Thomas continues, saying they did so by imposing the constitutional requirement that the new officer positions be established by law, rather than through a king unilaterally creating the offices. Now, the legislature creates the offices. The powers relative to the offices are partly legislative and partly executive. Legislature creates the office, defines the powers, limits its duration, provides it with compensation, position, and then the power to fill the office comes from the executive. So Congress creates the box, defines how big it is, how long it's going to last, what the box can do, how much money the box makes, and the executive branch fills it. The Constitution thus gives Congress broad authority to establish and organize the executive branch. Now, by keeping the ability to create offices out of the president's hands, the founders ensured that no president could unilaterally create an army of officers and then fill it with his supporters. Instead, our Constitution leaves it into the hands of the people, the elected representatives, to determine whether these new offices should exist at all. Now, long-standing practice from the founding fathers to today comports with this original understanding. Congress must create offices by law. The first Congress did this routinely. They created offices by statute. Here, we saw they created the office of the Attorney General, along with the U.S. Attorney for each district. They created the Secretary of War and his chief clerk, the Secretary of Treasury, a comptroller. Still today, Congress creates the offices that the executive branch may fill. Congress has created several offices within the DOJ. They created the AG's office, the Deputy AG's office. They created the Associate AG's office, the Solicitor General, and the Assistant Attorneys General. All of that is clear in U.S. code. But for some agencies, Congress has also granted the agency head the power to appoint officers themselves. And they were clear about this. Congress can create it, or Congress can create it and have the head fill it. But they give that power in the law. So the Department of Ag has it. The Department of Education has it. The Department of Health and Human Services has it. You know who does not have it? The DOJ. In the past, Congress has at times created expressly offices similar to the position that's similar to special counsel. They created an office for special counsel. That was some time ago. They investigated the Teapot Dome scandal and other prosecutions, and the statute for that created an independent counsel. But that statute lapsed. Congress hasn't reauthorized it, so there is no law there. And so we cannot ignore the importance that the Constitution places on who creates the office. To guard against tyranny, the founders required that a federal office be established by law. All right, James Madison cautioned about this. Said if there is any point in which the separation of the legislative and the executive powers ought to be maintained with greater caution, it is that which relates to officers and offices. If Congress has not reached a consensus that a particular office should exist, the executive branch doesn't have the power to create and fill it on its own. So Clarence Thomas continues saying, listen, it is difficult to see how Jack's office has an office established by law. Constitution says he should have it established by statute, and he doesn't. When the Attorney General appointed Jack Smith, he did not identify any statute that clearly creates the office, nor did he rely on a statute granting him the authority to appoint officers as he deems fit, like other agencies have. Instead, the Attorney General cobbled together a bunch of garbage statutes, and he cited 509, 510, 515, and others as justification for this. But none of the statutes cited by Merrick Garland, none of them creates the office of the special counsel, and none of them creates anything with clarity like other past statutes. Sections 509 and 510 are generic provisions about the authorizations and functions of the Attorney General. 515 contemplates an Attorney General who is appointed under the law, saying that, yeah, the office already had to be created. 533 talks about appointing officials, not officers. It's unclear whether an official is an equivalent of an officer, but regardless, this provision would be a curious place for Congress to tuck in the creation of a special counsel. And you also inserted that one into the provisions about the FBI, not the DOJ in the first place. So you're going into other agencies to say you have power to create a special counsel? That's the FBI law. Jack, stop stealing their statutes. To be sure, the court gave passing reference to the cited statutes that supported the special prosecutor in U.S. versus Nixon, but it provided no analysis of those provisions' text at all. And perhaps there is an answer for why these statutes do create an office, but before this consequential prosecution proceeds, we should at least provide a fulsome explanation of why Jack Smith's office is valid. They say, to be sure, Judge Clarence Thomas says, yeah, a few presidents have appointed special prosecutors, and they did that without appointing to any express statutory authorization. But this court had no occasion to review the constitutionality of their authority, so they didn't challenge that, right? Just because they appointed them historically doesn't mean that you can continue to do that. In fact, Congress gave the Attorney General the power to appoint additional officers as he deems necessary, but literally only for the Bureau of Prisons. So 18 U.S. Code 4041 says, yeah, actually the AG can appoint officers, yeah, but only for the Bureau of Prisons. So it's very explicit about that power, and he doesn't have it for the special counsel, saying that regulations also remain on the books that contemplate an outside special counsel, but I doubt that regulation can create a federal office without the statutory authority to do so. So Clarence Thomas continues saying, even if Jack's office has a valid office, even if he does, questions remain as to whether he filled that office in compliance with the appointments clause. So now we have to separate these out. Maybe the box is okay. Maybe the box is fine. But Jack Smith, this person who wants to go inside of it, is not. For example, it must be determined whether Jack Smith is a principal or an inferior officer. If the former, his appointment is invalid because the special counsel was not nominated by the president and confirmed as principal officers must be, so he fails automatically. But even if he's not one of those and he's an inferior officer, the Attorney General could appoint him without the presidential nomination and the Senate confirmation if Congress allowed him to do that. So special counsel's office is invalid unless a statute created that office, created the box, and gave Merrick Garland the power to fill it. So it has to create this box plus Jack Smith and then allow him to insert it into the box. Now, whether the special counsel's office was established by law is not a trifling technicality, okay? If Congress has not reached a consensus that a particular office should exist, the executive lacks the power to unilaterally create it on itself. Now, given that Jack's office purports to wield the power to prosecute, the consequences here are weighty. Our Constitution and our separation of powers, including its separation of powers to create and fill offices, is the absolute central guarantee of a just government and the liberty that it secures for us all. There is no prosecution that can justify imperiling this. And so in this case, Judge Clarence Thomas continues, saying there has been much discussion about ensuring that a president is, quote, not above the law. No one's above the law. Deduct 20 IQ points from any person who says that seriously. But as the court explains, the president's immunity from prosecution for his official acts is the law, always has been the law. No one's actually prosecuted it. It was, in practice, functional immunity until the Democrats decided to breach that. The Constitution provides for an energetic executive because the executive is essential to the security of liberty. Now, respecting the protections that the Constitution provides for the office of presidency secures that liberty. And so in that same vein, the Constitution also secures liberty by separating powers to create and fill offices. And there are serious questions here, whether Merrick Garland has violated that structure by creating a fake special counsel's office that has not been established by law. Those questions must be answered before this prosecution can proceed. We must respect the Constitution's separation of powers in all its forms, else we risk rendering its protection of liberty a parchment guarantee. Meaningless. Signed by Judge Clarence Thomas, making the right point that Jack Smith is illegally appointed, not constitutionally in his position at all. But the Democrats, through Merrick Garland and Joe Biden, continue to say he's legitimate, and the media accepts it. So the prosecution carries on. Now, this will go over to Judge Cannon in Florida, and we'll see what she thinks about this as she renders her decision on this issue and many others. But the point is, the immunity decision touches all of the cases. And this is even MSNBC acknowledging the fact that the J6 is not going to happen before the election, and Trump might win and put the whole thing to bed in the aftermath. Here is MSNBC reporting.
It seems, correct me if I'm wrong, there's no chance that any of these are taken up or go to trial anyway before Election Day.
Absolutely not. And Willie, one of the reasons that it doesn't is because it will take 32 days just before Judge Chutkan even gets the case back. That's because under Supreme Court rules, they have 32 days to issue the judgment back to the lower court unless somebody asks for it. The other thing is Judge Chutkan has to resolve what is in and out of the case before anything can proceed further. And what's in and out of the case has to go through the appeals process again before those pretrial proceedings can continue, because immunity isn't just immunity from liability. It's immunity from the whole thing, right? If you're immune from prosecution, you shouldn't have to go through the process to begin with. So I think there is no chance we see any trial before the election. And the case is going to disappear if Donald Trump is reelected. He will direct the Department of Justice to dismiss the case. He will get rid of the special counsel somehow. We should suffer no illusions that this case continues through the courts if Donald Trump is reelected.
Yeah, because Jack Smith is unlawfully appointed. He's got Clarence Thomas, who's there, also confirming that for us. And so we will keep our eye on what's happening over there. But Trump's attorney also came out and was saying they're going to use this immunity provision as it's intended. It's a broad provision that is going to protect Trump with a strong force field as it's protected other presidents. No other president has had to suffer through this political lawfare because we're going through a new era where communists have taken over and they're trying to ransack our own judiciary and our own justice system. But this victory continues continues, Trump's attorney saying, we're going to take this and apply it to every case. Alternate electors, Fannie Willis, all of them are now fair game. Here is Trump's defense.
Against you on this question of what's official and what's not official, that Trump must stand trial. I mean, do you acknowledge that there is still a chance he does have a trial here for the January 6th election interference case?
Well, first of all, I would note that Justice Barrett's opinion is a concurrence and it's not controlling. I think the majority opinion authored by Chief Justice Roberts very clearly sets out the path ahead. This case is going to be remanded back to the district court. The district court is going to have to determine which of the acts underlying the indictment are immune and which are not immune, and then we'll proceed from there. Obviously, any immunity decision made by the district court, we would have the ability to appeal on an interlocutory basis again up to the D.C. Circuit and potentially to the Supreme Court as well. In terms of your core question about the trial timeline, I think at the very least, we're looking at a long road ahead before this case could go to trial, which I think is appropriate given the very serious constitutional issues that this first ever prosecution of a former president presents here.
You have conceded here the last time that you and I spoke in April, and John Sauer, who was arguing this before the Supreme Court, that some of what's alleged would be considered a private act. So that would mean that at least part of this case from Jack Smith would go to court based on what you have said before, right?
We've admitted consistently that there are acts alleged in the indictment that would constitute private conduct, but we believe that if the official conduct, the immune acts in the indictment are stripped away, that Jack Smith doesn't have a case, that this case should be dismissed on that basis. I don't think there's sufficient private conduct here to support the indictment, to support the ongoing prosecution, and that's what we're going to be litigating in front of the district court now.
Even just the false slates of electors, you don't think that would constitute enough for a trial?
No.
Well, we would say alternate slates of electors. As we argued before the Supreme Court, alternate slates of electors have been a method used by previous presidents, most notably Ulysses S. Grant,
and Nixon,
to ensure the integrity of prior elections. So we believe the assembly of those alternate slates of electors was an official act of the presidency. That's what we argued before the Supreme Court. The Supreme Court has reserved that issue for determination by the district court, and we'll see how arguments fall in front of the district court.
Yeah, we've walked through those historical references here before. None of them compare to what we saw in 2020 with the fake slates of electors. But Will Scharf, great to have your reaction to this. Thank you for joining us tonight.
I would disagree with that, Caitlin, but great to be with you. Thank you.
That does not surprise me at all. Thank you very much, Will.
Well done, Will. I'm glad he got that in there at the last minute. She was trying to cut him off. You're just a big liar and a loser. No, you're wrong. Your analysis is crap, Caitlin. So well done, Will. On that, Jack Smith is now having to reconsider his entire strategy because he's now been outed as a political prosecutor and a hack who has tried to weaponize our justice system until the Supreme Court came out and brought some clarity to the entire situation, saying immunity clearly applies. And not only that, but Jack Smith is illegitimate. Clarence Thomas confirming that from his perspective, he does not have any authority to do anything that he's done. And so that is a nice hint over to Judge Eileen Cannon in Florida. We'll see if Trump maybe renews this in some of the other courtrooms. And at minimum, when Trump wins the Oval Office, it will be a nice justification legally to say, you get no more money. Where'd your money come from? No more money, illegally appointed. We're going to uphold the law. Jack Smith, you're gone. Goodbye. And those cases can go into the ash heap of history. Next video getting queued up is going to be about Florida because Trump submitted a reply as he continues to get the motion to dismiss granted in Judge Cannon's courtroom based on the spoliation of evidence destroyed. That segment coming up next, and we'll see you over there and back here on the next one.